Any mention?
May I please, Your Lordship, I beg to mention item number 13.
Item number?
13, 1-3. I pray for 2 weeks' time, Your Lordship.
And the objection, yes, Lordship.
Third, at the request of the learned counsel for the petitioner, list after 3 weeks. After
2 weeks' time.
Yes.
Hello,
Reply, Your Lordship.
May it please, Your Lordship. Lordship, I beg to make a mention of item number 5 and 6.
Your Lordship, the judgment has been delivered already. I can give a copy of it. It will be covered by the same. If Lordship permits.
Yes. This will cover.
My Lord.
Yes.
We'll have to go by that, Your Lordship, because it's judgment.
So why are you making mention? Let it come up then.
As your Lordship, yes.
Let it come up.
Your Lordship.
We'll just see, because this court does not know what the facts and all.
Yes.
You have to relate it with the judgment.
My Lord.
Just written for them. Just present.
May it please, Lordship. Lordship, I beg to mention item number 9. Your Lordship, I pray for 2 weeks' time, Your Lordship.
Who's your other side?
But 9.
Yes.
I'm for the respondent.
This is not the case which was heard at some length.
Lordship. Mr. Gautam is on leave.
Yes.
When?
Can have it next week.
2 weeks.
This is also at the request of the petitioner, list after 2 weeks.
Obliged, Lordship.
Lordship, I beg to mention item number 12, Lordship.
Yes, whatever.
Yes, Lordship. In this case, the similar matter is pending before Honorable Supreme Court, and the matter is for judgment only.
See, a similar, that is that matter, that existence of romantic relation or marriage. The matter has been heard by this court also. It has been kept reserved for order. Let us see what happens.
Lordship.
Because in that case, the counsel was basically pressing the court to pass some order.
Lordship.
So, cannot shut them down.
Lordship.
Just wait for the thing. We'll have it after
3 weeks, Lordship.
Okay, just say that is also at the request of 3 weeks. Okay.
Obliged.
Lordship, for item number 11, Lordship, I have a prayer for an adjournment. The matter may come up after a week, Lordship. Next week, it will be done. I have some difficulties.
Then let it be posted for after 2 weeks, Lordship.
After 2 weeks. 11, just say. At the request of the parties, list after 2 weeks. Yes.
Please, Your Lordship, I beg to mention item number 7 and 8. Your Lordship, let it come after 2 weeks.
We have no objection, Lordship.
7 and 8. 7 and
Yes,
8.
Your Lordship.
This also at the request of the petitioner after 2 weeks.
Highly obliged.
Yes.
May I please, Lordship, I beg to mention item number 14.
So the entire list gets exhausted. Yes.
May this matter come up after 1 week.
You are appearing for?
Respondent number 2.
Is the complainant
You are for the state.
Yes, Your Lordship.
quashing of the orders? My application under 311 was rejected by the trial
Who
court.
is the respondent number 2?
The complainant.
They have objection to your prayer. The complainant is objecting.
Pardon, Your Lordship.
Complainant is objecting to your prayer.
We don't know the stand.
They have not filed any objection.
No, Lordship.
Okay, we'll.
After a week.
After?
1 week, Lordship.
After 1 week. At the request of the respondent number?
Number 2.
Okay.
Highly obliged.
Much obliged, Lordship.
May it please your Lordship. Lordship, I beg to make a mention of item number 10, your Lordship.
Item number?
10, Lordship. Lordship, I believe this matter may be taken up after 2 weeks, your Lordship. I'm for respondent 1, 2, and 3, your Lordship. I have no objection.
Yes, 2 weeks. Yes.
Much obliged, Lordship.
Item number 1.
May I please, your Lordship? We need to file the paper book, Your Honor. Your Lordship. Not yet finished yet.
How much more time you need?
Give me 2 weeks.
Why it is listed for admission? Why admission? It is already admitted. It should be in the orders. Once it is admitted, then admission is over.
Give me 2 weeks time.
2 weeks.
Yes.
Okay. As requested by the appellant, another 2 weeks time is granted for preparation of paper book. Yes.
Much obliged.
List accordingly.
Item number 2.
Affidavit for respondent 9 to 11 not yet filed.
Your Lordship, I pray for further
How
2
long it will
weeks.
take? Just say.
3 weeks, Your Lordship.
Only.
3 weeks, Your Lordship, because we have
It can
contacted.
take 2 months also. If you have to take, see, time like this, every time you come, 1 week, 2 week, 1 week, 2 week, and ultimately you take more than a year. Then what is the purpose of asking for 1 or 2 weeks? We can understand initially 1 2 occasions, okay, but this is repeatedly you are doing the same thing.
Your Lordship will make sure, Your Lordship, on the next date will surely come up with something, Your Lordship.
Lordship may record it as a last chance.
If you give last chance and if it is not filed, then what happens?
Then the application should be filed.
So it is not
Under what
it
circumstances?
will basically increase burden on the parties and the court. See, there has to be seriousness to get the matter disposed of. Until and unless it is not there.
Then it may be closed,
Yes,
Lordship, in
last
the
chance.
interest.
Last chance, Your Lordship.
SK Guru, Joint Counseling for appeal for the respondents has again renewed the prayer, has again asked for grant of some more time for allowing the respondent number 9 to 11 for filing an affidavit. The learned counsel for the petitioner has vehemently opposed the prayer. On the basis that, do not say on the basis, on the ground that the said respondents have been given enough time to file affidavit in the well, a perusal of case report reveals that respondent number 9 to 11 have been granted time repeatedly for filing their affidavit. However, for ends of justice, another 2 weeks time is granted as last chance. Make sure if you don't do it, then for filing the affidavit. Last chance granted 2 such and such, okay? As last.
Much obliged, Your Lordship.
List accordingly.
Hearing item number 4.
Your Lordship, I pray if this matter may be taken up at the end of the board, Your Lordship.
At the end of the board. Okay, why?
Your Lordship, as in this matter, Your Lordship, we were supposed to seek some instructions, Your Lordship.
Who is for petitioner? Yes, what is the matter about?
The conducting counsel, Mr. K.P. Bhattacharjee, also prays for a short passover. End of the board, my lord.
Okay, at the end of the board. Just call it.
Much obliged, Lordship.
Item number 5.
Yes, Mr.
Lord.
Yes, what is the matter about?
My Lord, the brief fact of this case herein is that, my Lord, we were aggrieved by the supplementary demand notice from the Cantonment Board asking for amount of amounting to rupees 21 lakhs.
Supplementary demand notice, why supplementary? That is in addition to the rate prescribed.
In addition to the
That's
present
what, as rent.
rent, lease rent, Your Lordship.
So there was an enhancement of that.
An exorbitant enhancement, that was our contention, Your Lordship, based on the standard, the so-called standard table of rent. So aggrieved by that, Your Lordship, we have SCL before this honorable court, our aggrieved.
And then that was decided. The same issue has been decided by other courts.
Same subject matter, Your Lordship.
See, so we can say that this matter will stands closed in terms of the order passed by this. That will do.
Sure.
Or do we have to pass a detailed order?
It would cover the same thing. Otherwise, unnecessary to exercise double.
So what happened in that matter that has been allowed? Your petition has been allowed.
No, dismissed. Because there is no arbitrariness, nothing has been found. The enhancement was as per the Act, reasonable. Lordship could come to page 19 at the bottom, Lordship. That will give the gist of the.
Presenting of the writ petition.
No, this judgment. Para 19, Your Lordship. Yes, prior to that, it was held that the DCS complied with asking for the schedule of rent. Then 19, it says, on the other contention regarding issue or demand notice by the respondent number 4, CEO Ceylon Cantonment Board to the lessees demanding exorbitant amount in lieu of the advance rent occupation charge in respect of the leasehold properties, it is seen that this action is as per the interim policy dated 10/3/2017, wherein provision for issue of demand notices had been given in cases where the full term of the lease had expired. The lease expired. Further, the STR standard table of rent on the basis of the land valuation of the zone as provided by the Deputy Commissioner monthly rent has been calculated at 2.5%. This is as per the law. 2.5% of the total market value for residential purpose as per the letter dated so and so 11/1970, and for the commercial purpose as per the policy of 10/3/2017. The procedure adopted by the respondent, therefore, in the concept of the court does not suffer from any arbitrariness or illegality.
So, is it the same impugn order which was challenged?
Same
Date of order is also same.
Yes.
So then definitely that will definitely.
Same.
Okay, how many petitions are here?
Two petitions. Same. Para 21 also the same thing.
See, your challenge, what was the challenge there before? What was the thing?
Their condition, if your lordship wants to explain, your lordship, what suppose 90 years back, the rate is fixed about ₹100. After 30 years, 50% will be enhanced. So 150 after 30 years. Then again, under 30 years, under 50%. It will come to 200 something. Then again, under 30 years, that will be 50%. So they want to stick that, but that policy has been done away with. Because those we agreed till the expiry of the lease. As soon as the lease expired, so the new rent has come into play. So those, the old policy, that has been done away with.
But what expressly they prayer in the petition? This is
to stay the.
Well, what is seen in the last order, you see, there's nothing specifically impugned here, isn't it? No, there is no impugn order. In the writ petition, there is nothing, no impugn order, isn't it?
Yes.
Now, their prayer was for fixation of rent in accordance with
the new STR.
Was it something like that?
Based on that policy dated 10/3/2017, Your Lordship.
Just give some time to the court. The court get the fact. in this present writ petition, the prayer is for quashing the supplementary demand notice dated 7/6/2018.
Yes. Because that is based
There
on
are
the
three orders.
yes.
Now, whether those were the same thing there?
Same thing, same thing, same thing. Initially, these are the 2019 they filed it, Your Lordship. Then those cases decided they were filed in 2022.
Now, you wanted some quashing of some proceedings also
My lord,
under section 4 of this.
eviction due to non-payment of the demand amount.
Now,
Your
what
lordship.
the court arrangement said about that, the last part, operative part of the order?
Operative part of the order said there is no arbitrariness in the revised STR and no illegality has been committed, neither from the state side nor from our side. Everything followed by the procedure of the law.
No, but then there it has not been, nothing has been said specifically about these prayers.
About?
Those prayers which are made in the writ petition, nothing has been specifically said in the order.
Only they bifurcate that this procedure, one part arbitrariness and another with regard to the revision, whether it has been followed the procedure or not.
That is so far as the merit of the matter is.
Yes,
That is
merit,
the gist of the argument.
yes.
Now, what this court is asking you is that there are some specific prayer with regard to issuance of some letters and drawal of proceedings. In this case, present case, please come to the prayer. In the present matter,
Yes.
please come to the prayer. We do not know whether you are getting it or not, whether the query of the court you are getting or not. Are you getting the query of the court or you are not getting?
No, the present matter.
Are you getting what this court is asking?
Yes, yes, Lordship.
See, kindly come to the prayer part. Come to page 13 of the writ petition, which the present writ petition. Yes, please look below down, then you will find.
Quashing and sitting aside the supplementary demand.
Yes.
Later dated 7/6/2018, number so and so.
And so and so.
75. Right.
Similarly, come to number 2.
Number
There
2,
is
quashing the
quashing of
proceeding
proceeding.
initiated before the court of state officer, which show cause notice that is so and so under 4142B
Yes.
of the public process. So those will be
And then come to number 3, there is also another.
quashing clause 1(3) of the interim policy dated 10/3/2017 as being dehodes the provision of the Cantonment Land Administration Rules
Now-
1925
It's
and
all
the
right, it's all
Cantonment
right, it's all right, it's all right. Now tell us whether the same prayers were there before the other court.
Yes, same prayer.
Same prayer.
Same prayer.
Now, how this prayer has been, this thing?
No,
dealt
this
with?
this has been dealt with. The number 3 has been dealt with, Your Lordship.
Where is?
It is dealt with. Your Lordship will see.
Now, how? What the court has held there to negate this prayer?
Dehodes the provision of that. That's what is the main contention, Your Lordship.
Where do we get it?
I'll
Which
just-
part of the judgment deals with that part? This prayer.
Yes. I'll come to that.
Because you know your case, this court doesn't know it.
Obviously. I'll try it. Then paragraph 15, Your Lordship will give the clear page 13, Your Lordship, of the judgment. If Lordship permits him to read. Having heard the learned counsel for the parties, it is seen that in these writ petitions, two main issues have been raised. That is the standard table of rent STR of Shillong Cantonment and the revision of rent done on the said STR. The contention is that the STR has been determined incorrectly, which as submitted has resulted in exorbitant increase in the lease rent. Before coming to the grievance of the petitioner, it would be expedient to outline the method and procedure that is adopted in the fixing of these rents by the cantonment area. The preparation of STR is governed by the Ministry of Defence, Government of India letter number so and so dated 31/176 which inter alia provides that for determining the value of land, each cantonment may be divided into zones such as bungalows, civil, shopping, etc. These lands are then identified with
And that is
similar
okay. That
lands.
is a decision on merit.
Yes.
Now what?
Then their
when it
policy
came
has
to-
been.
when it came to the rejection of prayer.
Yes.
Okay.
Then can I just go through para 16, Your Lordship? With regard to the STR for residual power, the Ministry of Defence by letter dated 11/1/1976 decided the same was to be 2.5% of the market value of land and has provided in the letter dated 31/1/76 at para 7 thereof, the STR would be revised at least once in every 3 years instead of 5 years, except in the case of fast developing cantonments where the revision was to be carried out every 2 years. The extract of the later dated is reproduced here and below. So this is a yeah. Then, Your Lordship, para 17, the respondent had also put in place an interim policy for the lease dated 10/3/2017, which provide for the extension of expiring cantonment lease so-and-so 1899, 1912, then 1937, and for renewal of cantonment code and CLR lease, cantonment land regulation, CLR lease whose full term had not expired. By this policy decision, leases whose full term has expired or were expiring before 31/12/2018 were extended till 31/12/2018 subject to condition mentioned in paragraph B3 that this land shall be recovered from the lessee based on STR rates prevailing on the date of expiry of leases. So they have given this as per 10 March. This has been given about the later. Now, next at page 18, this policy has been extended by the Ministry of Defence from time to time, last by the letter dated 29/12/2022 for the period of 1 year and till finalization of a new policy beyond 31/12/2022, as a D of the affidavit of the respondent 1 and 2. Thus, it is seen the fixation of STR pursuant to the list of granted under Cantonment Codes 1899, 1912 and CLR of 1925 and 1937 were regulated as per the said procedure and policy by the respondent 1 and 2 as narrated above. What has to be examined by this court is only as to whether the fixation STR as per the adopted policy for the relevant period and recovery made in accordance thereto. First, it is noted that as per the stipulation, concurrence of the Deputy Council East Council was obtained by the respondent 2 on STR for Shillong Cantonment with effect from 1/1/2018 to 31/12/2020. And respondent number 2 had revised the STR rates based on the said inputs. It is, yes.
Now there the court said that the details guidelines of 1976 and 2017 has been followed.
Followed, yes.
So that once that is followed, so there is no case, isn't it?
Okay, yes.
Now this entire case is based upon
on that.
The contention that it was not followed. Those
that's
that.
That's
is that?
Yes.
Yeah, both the petitions are same.
Same
With same sort of prayers.
Dicto, my lord.
No difference.
No, my lord.
Because initially these are the two cases filed. Then thereafter in 1922 they have 2022 they have filed the other case.
Okay. Just this set of two petitions. This will be 5 and 6. Item number 5 and 6. Identical. Involving identical comma involving similar issues. And are taken together with taken up together with the consent of the learned counsel secretary to the case. Mr. Shula, you are also there.
We are for respondent 235, Your Lordship.
235.
The paragraph just say the
No, 5, no. 2, 3. Yeah, for 1 and 5.
just record their name respectively. Okay, 2 is there. Then paragraph, the above two petitions have been filed. With prayer. Just say with following prayer. Then you copy the prayer at page 13 from here. Okay, close 1, 2 till the last. Okay, stop. Then give a paragraph. The learned counsel thanks for the parties submit that the issue involved in this matter has been dealt with by a coordinate bench in WPC number 343 of 2022 and WPC number 344 of 2022 and by judgment and order dated 5/6/2024. The writ petition containing the similar prayer, writ petitions containing similar prayer have been rejected. The learned counsel submit that the same judgment would squarely cover up the issue raised in this sets of two writ petition, raised in this set of two writ petitions, and the shall we say stand dismiss? Okay. Okay, give a full stop. Give paragraph. The paragraph that's in view of the submission made by the parties, this two writ petitions also stand dismissed.
Dismiss or
But the problem is that, you see, I do not know why the difficulty is that, shall I say. We do not know whether that judgment preferred by that judgment rendered by the coordinate bench will be appealed or not. Now, whether this here it is a
That is for them to take a call, Your
the
Lordship.
problem is that this court is conscious about the fact once we take it as a consent from their side, then their appeal will be barred. So that is what the problem is. You see, the court is hesitant.
No, I agree.
Once they are agreeing, so you do not have any difficulty to close this matter.
We have to go by that, my lord.
So what?
So that is
Okay. You do one thing. You make there on the first part we said that parties submit. Okay. Rather you do it this year. We'll just say the skin. You see something. We just say the learned senior counsel appearing for such and such, and Mr. So and so AG submit that this present matter is covered by the judgment and so and so. Okay, instead of saying the both the parties, and down below after doing these things, okay, before we say in view of submission, you just say learned counsel for the petitioner also does not dispute the submission advance and consents for the closure of the matter on the basis of the say judgment order. This is all right.
My lord.
See, it should not be something like that. That later on you say the court has not corrected your submission later.
My lord, that's my instruction. I have to go by that, my lord.
Okay. Oh, okay. Just you say that London Council of the petition also does not dispute the submission and submits that this matter may also be closed on the basis of the order passed in writ petition number so and so so and so. Then you say the paragraph in view of the submission, these two writ petition stands dismissed.
Both the cases.
No order to post. We'll just correct it accordingly here,
Yes,
there. But then just do not want to go by that.
I
thing,
understand.
so that it causes any hindrance for you. Mr. Shula is
if that is
smiling.
overturned, Your Lordship, then they cannot come before this court to seek a review on the change of law.
that is what, see, like this court is very much conscious about that.
Oblige.
Oblige, Your Lordship.
No, that is the ground. Me as a senior counsel, I don't think that this is a ground.
No,
that
once he is not disputing,
yes,
that is not,
yes.
see, you have nothing to
Yes,
say.
I-
But then even then we thought,
Yes,
suddenly it
I
came to me. See, like the court was conscious while passing this, so that is why it was
Obviously.
disturbed. Its thought.
Deeply obliged, Your Lordship.
Much obliged.
Second call, item number 4.
Deeply obliged. This will be 5 and 6 will be same. Same order means just you see that copy of the order which has been kept there, and then just from there. Yes.
The Union of India is to get some instructions. I don't
What?
know whether they've.
Instruction for
My lord, what had happened, my lord, when this matter come up for hearing before the Honorable CJ, my lord, I had stated that, my lord, as far as the test is concerned, my lord, there was no earlier intimation given to me. It was conducted on the same day, my lord. Therefore, there was a query from this Honorable Court, my lord, that what was the status of the other candidates? Because the court wanted to know, because otherwise, if their test is conducted on a separate day,
what is the order passed by the order which you are referring to?
My lord. My lord, it is order dated 19/3/2024, my lord. And my lord, even from my side, my lord, I have filed RTIs, but unfortunately, my lord, even the first appeal RTIs were rejected, my lord. First appeal is also rejected. Thereafter, I filed second appeal, my lord.
Now, this court says that thereafter he was asked to appear in examination, that means you, for the post of constable cook, conducted by the board, and he was successful on 5 cents. And the very day a trade test was also conducted, and petition found unfit.
My lord, this is what we have challenged before this.
No, but then you are found unfit or not suitable. Unfit is something which challenges your candidature. That means you do not fulfill the eligibility criteria.
I was found unfit only on this test, my lord.
Okay. So the order says that you are unfit. Test which does not, which did not find you suitable, did say unfit. The earlier, the order of the court says that he was found unfit.
I will go through it. Yes, my lord. It says unfit in trade test.
Okay.
It is at annexure 8, my lord, page 40.
That is how it has come, otherwise. Okay, so your instruction is limited only to that thing.
Yes, Lordship.
That whether the trade test was taken up on the same day, the written test was conducted.
Yes, Lordship.
Yes. Now for that also you were taking time. You have instruction now.
No, Your Lordship. But then the learned DGI wants to.
So you do not intend to take an instruction.
My lord, on that same query, my lord, I have also filed an RTI. My lord, my RTI was rejected.
Then say supposing if it is not held on the same day, then which way it advanced?
My lord, my case is that, my lord, prior intimation has to be there, my lord.
For trade test?
For any test, my lord. Now, my lord, if the day I appeared from the for the physical test, my lord, if let's assume, my lord, I am one candidate.
Which way you are prejudiced?
Lord, my lord.
You see, we can understand your contention. We will uphold your contention once you can show that your contention has some force worth acceptance.
My lord, for any test.
Wait, just a minute. Just allow the court to complete. Now, if you want to say, we assume that there is no definite set of, you see, the rules which can say that, you see, that the two sets of examination should not be held on same day, or one exam should be held after 7 days of the first exam. You see, and in absence of any such rule, the contention which you raise, you say that your written examination and your trade test was held on the same day.
Same day.
But then so far for the other candidates, it was not done on held day, same day.
No, my lord, that query, my lord,
No,
that
is it your case?
My case is that, my lord, that I should have been given sufficient opportunity. There should have been prior intimation.
So that is what your case is exactly. That is what the court is saying.
My lord.
You want to say that after your written is over, for trade test, you should have been given some more time.
Yes, my lord, separate day.
So that is what. Yes. So that we can say that your contention is that it should not have been held on the same day.
Yes, my lord.
So that is what. What the court is saying, you are saying it in different ways.
And my lord, even assuming that it is
now,
held.
The question comes that if it is done on the same day, which way you are prejudiced?
My lord, because I was caught unaware, my lord. This is a sudden.
No.
My lord.
See. It is not a kind of thing that you appear in some written exam where you need some time to prepare. Here it is only projection of your skills.
No, my lord.
The skills which you possess with you.
My lord, there is one.
Wait. You are a good sportsman. You can perform something very well. And you have been asked to perform. You perform. You fail to perform. Because this is a skill you carry with you. You are a good singer. It is not like that the written examination, you have to prepare many things and come and as cooking especially. It is not that you will be given time to learn cooking, come and appear. You take part in examination because you are already an expert in that area. Isn't it? So until and unless you can find out something to show. Because one thing is that you just cannot equate yourself with the regular set of candidates because your exam was a kind of special test. Because initially you were debarred, isn't it? Subsequently a special opportunity was given to you because it was found out that your debarment was wrong. Now the special test was held. Now your thing is that sufficient time should have been given. This exam should not have been held on the same day.
Yes,
written exam, trade test. Issue is confined to that. You have to place us before something in law saying that the such kind of practice is
My lord,
not acceptable in law.
my lord, my respectful submission, my lord, is that in order to give me a fair chance, my lord, fair opportunity, my lord, they should have held the examination on the separate date. Another factor, my lord, because they have given minus point to me for not producing any certificate. I have not got any marks. So, my lord, I was never prepared. My lord, what my contention is that, my lord, if that is so, my lord, if paucity of time is a question of fact, my lord, then they could have done the same thing on the day I qualified my physical. That very day they could have.
You see, you cannot say everything how you should.
My lord, the call letter should have.
Remember one thing, that you are examining. Whatever you want, that will not be done the way
No,
you.
my lord, my lord.
Wait, just hold it. It's kind of understand the rules. It is the authority concerned who will fix in which order things should go. You do not have a say in it. But then, if you find that their fixation causes prejudice to you, then only you have a case. Okay. Now, it just cannot be an argument like this that in such a case, physical examination should have been, and written examination should have been the same day. No. Your thing is that you can establish a case when you can show that prejudice has been caused. That is what.
My lord, the call letter for written examination. My lord, that if that is so, my lord, the call letter for the written examination should have stated that if you stand successful in the written test, then thereafter you will have to sit for the trade test, my lord. So there is no such intimation even in the call letter for the written test, my lord. Whereas in the as far as the physical test,
Mr. Bhattacharya, please, we understand, we appreciate that.
my lord.
Now, because of non-adherence to what you are saying, which way those are prejudiced you? We cannot go by assumption. You are a cook, you are a chef. So we go by that. And when I know that you are a chef, then we understand that the moment we place some ingredients before you, you should be ready to prepare. Because this is expertise which carry with you.
My lord,
So in view of that, then you have to show us which way you are prejudiced. Because of, you see, allotment of time for you, to you, for preparation, that you have suffered. That is what you have to establish. It is just because you just that they should have given. That cannot be reason. Why they should have given, that is the main thing. The time.
My lord, my respectful submission, I will try to get some judgments also, my lord, but this is a very peculiar case. But my lord will kindly understand, any government examination, my lord, there is always a prior intimation, even if it is a trade test, my lord. There has to be a prior intimation, my lord. You cannot take me by surprise.
We understand that. Okay, if there is not, then what happens?
My lord, then that is why I am unprepared.
Something, you see, if it is not there, we can understand that. You have said it many times, and that is the case foundation of your case.
My lord.
We can understand that. And even for the persons, those who are recruited through the same recruitment process, for them also, some time was given, date was fixed. But then in your case, no. In your case is slightly under different footings because initially it stood disqualified. Subsequently, they found that no, you are eligible, isn't it?
So my lord,
wait. That means a partial test was conducted for you. While conducting the special test, they did not give you the opportunity which you are given to the other candidates. Okay, mostly because they appeared on written test on one day, or trade test on a different date. But then for you, it is on the same day, immediately of completion. Okay, so now you say because of that you have suffered. It is your case.
One of the grounds, my lord.
Is it? And what is the other ground? That you did not file a certificate. You did not file a certificate.
That of course, that is a part of the same ground, my lord.
Basically, anyway, then these are the non-partition of certificate.
My lord,
what is
other ground is the bias, my lord. They are already had a premeditated mind, my lord.
That is a different thing. Biasness has to be assumed from the establishment of the facts which you say. Okay. If you can show some kind of prejudice in holding your examination then and there, then bias will be stand established.
My lord, in my affidavit, I have stated, rejoinder affidavit, my lord, there is a specific environment, my lord. When I went for the exam, my lord, I was told that you sit for the exam, but you will not get. That
okay,
environment I
how
made,
do you
my lord.
prove it?
That difficult to prove, my
Did you
lord.
file immediately any complaint thereafter? You
That
should have filed it to the superior authority. You can understand the scope of writ jurisdiction. We cannot go to the facts, record evidence to establish these facts.
my lord, that aspect.
So that must, you know your limitation. You are a mature lawyer. You are a seasoned lawyer. At least in a writ petition, what can be entertained, what cannot be entertained, that you know it very well.
But as far as fair opportunity, my lord, my case is that there should have been a prior
So
intimation.
the fairness and unfairness has to be decided, isn't it? Okay, just because somebody is given 3 days time and you have given three hours time, okay, it may sound different. Okay, you may say that they have been given 3 days time, I have been given 3 hours time. Yes, but then until you show that what prejudice has been caused, two things. You see, it was not like that you are appearing in exam to get some qualification and all. It was not that. It was a test with regard to your expertise. You understand?
Yes, my lord.
You go there, you take part in exam.
My lord, my lord is correct. But my lord,
See,
let's say,
So that is where you have to show us.
my lord, if we assume one situation, my lord, there are times, my lord, when let's say there is a selection for typist, my lord. So, my lord, there is a written examination. The person qualifies written examination, my lord. Then thereafter, my lord, the call letter in the written examination never says that your typing examination, if you are successful in the speed test, your typing examination will be conducted on the same day. So, my lord, after being successful, suddenly there is an intimation that your typing test will be taken today, my lord.
It's okay, but then which way you are prejudiced by that? You are already good typist. That is what the answer which the court is doing. We can understand. We can understand. You see, if you say that your performance had suffered because of, you see, like no opportunity was, no sufficient time was given to you, in such a case, you have to show us how it suffers.
My lord, the call letter should have said your trade test will be conducted on such and such date.
It is not said. It is not
Bring
said. We
whatever,
understand.
if you have any certificate, please bring along.
You are again saying that, but then what is the prejudice? Just tell us how a typist's ability or a cook's ability gets suffers. You are a good cook. I tell you, you prepare meat today, right now, and prepare it tomorrow. What difference it will cause? If you can say yes, I did not have the ingredients. They did not give me salt or turmeric. We understand that. It is not your case. You had all the other requirements which are needed for cooking.
My lord, the item which I cooked is totally different, and they have had also.
That is, you see, you cannot expect that whatever has been done.
And
you are cook. You have to cook everything. It is not that you only can make dal. You become good cook. You can say this kind of arguments will be very difficult. Very difficult to be successful in this kind of things. Court understands your thing. We can even say the yes. So far as the others are concerned, you may not have been given the same kind of opportunity. The opportunity given to you was lesser than what was given to the other candidates. But then, to you see uphold your contention, at least you have to show that some prejudice has been caused. It is not that you have asked to appear in science examination. Others were given 3 days and you have been given 3 hours. No. Where you did study, it is a cooking. I'm a good cook. You tell me to cook now. Right now I'll cook it. Okay. Provided you give me ingredients. Okay. I just cannot say that for cooking I need mental preparation. I have to do meditation. I have to go home, ask from my mother, my sister, how this is to be done, and next day come and prepare. Should not be something like that, isn't it?
That is true, my lord.
Yes, madam. What is how long you will take to take this minimum instruction?
Your Lordship, the learned teacher was supposed to deal with the matter, but then he's on legs, Your Lordship.
No, but then instructions you can also pass it. Depending on your instruction, we can list it for hearing. But then instructions should have been there.
I have no instructions as of now, Your Lordship.
So, It is, you see, order has been obtained at your behest, so you have to wait for the instruction. You cannot decide it without getting the instruction. But then ready to answer with this. You have to bring out something that at least that even expert performance may suffer due to non-sufficient of, you see, not due to this thing, deficiency of time, or due to what you say, non-accordance of you see sufficient time. No, you have to do some research on that line.
My lord, I'll do some research.
Cooking is something, you see, it is not that if you cook right now, you are an expert cook, and if you cook right now, and if you cook tomorrow, what you prepare right now will not be tasty, and what are you prepared to the may be tasty. Cannot be. It may be totally.
That is there, my lord. But there was a written, my lord. He was asked to write how to prepare the chicken curry. So, my lord, they are basing solely on that. They are basing that he does not have
But then
any.
it is your performance in the exam, isn't it?
My lord, the practical where I cooked, that they did not make a single whisper, my lord. What the item I cooked and what the officers had, there is no mention of that.
Supposing, you see, if you do not know the basic ingredient of cooking, then that should be enough, isn't it?
My lord, there are times.
This code has some idea of cooking, so you will be in problem, you see. Anyway, we will have it some other. Just see, make a research on that.
My lord.
Otherwise, it will be a difficult case for you. When this your result was declared, and after how long you have approached this report?
Immediately, my lord.
Okay, it's all right.
Result was declared in 30th January 2017, my lord.
And when
This
did you
writ
file?
petition is also of 2017, my lord. This was filed.
Any interim order passed in this case?
No interim
Did
order.
you get any
There
interim
was no
order?
interim application. my
No
lord.
direction was made to keep one post vacant or something like that. No.
My lord, no, that was not there.
Even if court finds that you have a case, then also court cannot pass an order directing them to take you in service. You may be entitled to appear in exam again. Nothing more than that.
My lord, my contention is that only, my lord, that you give me another chance for trade
You will
test.
come prepared, totally prepared, isn't it?
That is my only ground. My lord,
They may not again ask you to prepare chicken curry. They may ask you to prepare something else.
No, my lord, what I practically prepared was vegetable item, my lord.
Okay.
My lord,
Anyway, it's okay. It's all right. Okay, miss. Hey, Guru.
my lord, there is a prayer is there, my lord. That further pending disposal of the instant
That is okay,
expedition.
but then there is no interim order.
Direct the
Activance is no
respondents to
interim
keep
order.
one post. I'll have to check.
Now,
also,
if you become successful and if you find that all the posts are vacant, then
posts are vacant, my lord.
Oh, sorry, all the posts are filled up. Then what happens?
My lord, I'll have to check the detailed orders.
No, you do not have to. Do not take it this thing.
In the
Court is yet
meantime,
to
I
hear
will
it.
check the
Court will
detailed
hear
orders
it on
also.
merit. Okay, but then one thing you should be conscious that the writ court doesn't issue futile writ. It means a writ which cannot be implemented.
My lord.
Okay. Miss so and so, Learning Council appearing for the respondents. 6 further time for obtaining necessary instruction in the matter. You have no objection.
My lord, because
Petitioner has no objection. Whatever reason,
unless the instruction is there, my lord.
petitioner has no objection, then you say prayer allowed at least after 2 weeks. You can have within 2 weeks.
Yes,
Or need 2 months.
2 weeks.
Okay. That is what.